Major breaking news out of the United States Supreme Court. The Supreme Court has decided to grant cert but vacate and remand the United States Court of Appeal for the Third Circuit's decision in Lara dealing with 18, 19, and 20-year-olds' right to keep and bear arms. Let's break down what this means for the Lara case itself and for future Second Amendment cases before the U.S. Supreme Court when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon. All right, so we have major news today. Some people view this as bad news. I'm not sure it's bad news. I think it's more just normal news. Specifically, as you may recall, the United States Court of Appeals for the Third Circuit out of Pennsylvania, Delaware, and New Jersey issued a favorable ruling in favor of the Second Amendment in a case called Lara versus the state police of the Commonwealth of Pennsylvania. And in the Lara case, they said that a Pennsylvania state law that prevented 18, 19, and 20-year-olds from carrying handguns when a governor declared a public emergency. I think I basically got the procedure right here. That in a situation where the governor declares a public emergency, 18, 19, and 20-year-olds are denied the ability to carry guns in public, which otherwise they are allowed to carry in Pennsylvania. And this was challenged, went up to the U.S. Court of Appeals for the Third Circuit in Philadelphia, and the Third Circuit ruled in favor of the Second Amendment. Now, this is a key fact. They ruled in favor of the Second Amendment before the U.S. Supreme Court decided the Rahimi case in June of 2024. Today, the U.S. Supreme Court has granted cert in the Lara case and vacated that decision in favor of the Second Amendment and sent it back down to the Third Circuit for further consideration and reconsideration later Rahimi. And to keep in mind that even though we won the Lara case, the state of Pennsylvania sought cert to the U.S. Supreme Court, asking the Supreme Court to find that 18, 19, and 20-year-olds have no Second Amendment rights because essentially they're not part of the people. In the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. Now, this cert petition was sought again by the state of Maryland, by the anti-gun movement, if you will. And in somewhat of a perfect world, I suppose, we would want the U.S. Supreme Court to deny cert, which would allow that Third Circuit ruling to remain on the books. But that's not what the U.S. Supreme Court did today. They granted cert, vacated the lower court decision, and sent it back to reconsider in later Rahimi. Specifically, what the Supreme Court is indicating to the Third Circuit is they want the Third Circuit to redo their analysis of 18, 19, and 20-year-olds and whether or not they have Second Amendment rights and when can they be restricted, if at all. In light of the Supreme Court's decision of Rahimi, probably because the Supreme Court views the Rahimi decision as clarifying the use of historical analog laws and deriving principles that can then be applied in modern-day America. Now, many people think this is a negative. I think this is more of a normal situation. Let me tell you why. Step back, view this from the big picture. What have I always explained to you about the U.S. Supreme Court every term? The U.S. Supreme Court, for better or for worse, hears about 70 total cases a year on the merits. 70 total cases. That covers all of American law, contracts, torts, federal statutes, constitutional issues, First Amendment issues, Fifth Amendment issues, criminal cases, and so on, including Trump-related cases, presidential cases, and so on. The reason why that's significant is I think historically the best we can hope for in a given Supreme Court term is for the Supreme Court to hear maybe 2 to 3 Second Amendment-related cases, gun-related cases. As we sit here right now, in October of 2024, for this term of 2024 through 2025, the Supreme Court has granted cert in 2 gun-related cases that speak to the Second Amendment in effect, even though they're not Second Amendment cases. One, of course, is the Vanderstock case dealing with the framer-receiver ghost gun rule of the Biden administration, which I suspect if Trump gets elected, which we hope happens, that regulation will simply just be written off the books as a matter of executive order or procedural process through the executive branch. The Second Amendment-related case, although it doesn't speak directly to the Second Amendment, is the Mexico versus Smith & Wesson case. This is the case where the government of Mexico sued in Boston, the perfect jurisdiction for anti-gunners. the government of Mexico sued in Boston, the major gun industry players, including Smith & Wesson, trying to hold them accountable for alleged criminal activity by criminals in Mexico that were somehow acquiring these guns from American gun manufacturers. And the gun industry asserted the PILCA statute, which is the Protection Lawful Commerce in Arms Act. They asserted that as a defense, as an immunity defense, and the First Circuit Court of Appeals out of Boston rejected that. And now that case is going to the U.S. Supreme Court, a very important case for America's gun industry and by extension the Second Amendment. So those are two cases the Supreme Court is already hearing this term. So we in the Second Amendment community, as I see it, this is my opinion, we probably have room for maybe one more Second Amendment case. Maybe two, but I doubt it. Maybe one more. Now, you know and I know what I'm about to say. The Second Amendment case that we really, really want and need for the Supreme Court to hear this term is not the Lara case that was just GVRed back to Pennsylvania, back to the federal courts and the lower courts. We want the Supreme Court to hear the Bianchi-Snope case, which is going to be conferenced for the first time in December, likely will be relisted into January, with hopefully, we hope and pray, a cert grant coming in January. That's what we hope. Or cert denial with a dissent, presumably. I don't know. But what we really want is the third gun-related Second Amendment case to be Snope's Bianchi. Because as I see it, there's no more important case in American gun law right now that we need resolved in our favor, and it should be resolved in our favor, is that AR-15s and semi-automatic rifles are protected arms under the Second Amendment. Now, this should be a slam dunk case, applying the Heller precedent. But I don't know what the Supreme Court's going to do. I don't control them, but it seems to me this should be a very easy case given the Heller decision. But we're not going to know this for several months. Now, the reason why I give you this background in the context of today's GVRing of Lara is to give you hope, to give you optimism. Because the reality is, I've told you that Lara was not the right case for us to resolve the 18, 19, and 20-year-old issue. The right case, as I see it, is really going to be the Reese case out of the United States Court of Appeals for the Fifth Circuit, because the Reese case is being decided right now. I think we're going to win that, and that's going to declare a federal, hear what I just said, a federal national statute that said that 18, 19, and 20-year-olds cannot own guns, or cannot buy handguns, from FFLs or federal firearm licensees. That is the Reese case out of the Fifth Circuit. That, I believe, will be a panel decision that says that federal law is unconstitutional under the Second Amendment, and the U.S. Supreme Court will almost certainly have to take that case, and that is the best, in my view, the best mechanism or means by which we get a clear ruling that 18 and 19 and 20-year-old young adults have the same full-blown Second Amendment rights as any other American citizen. That is the vehicle as I see it, the Reese case, not the Lara case. I've said this for some time. So the fact that the Supreme Court GVR'd Lara, I do not take as a bad sign. Keep in mind, again, it's a little quirky jurisdictionally because it only gets triggered when the governor declares a state of emergency or there's a state of emergency declared in Pennsylvania. Otherwise, it doesn't apply. And I know that Chief Justice John Roberts is not a fan of these kinds of quirky jurisdictional issues. He much prefers a final judgment on a clean, clear issue. And I think the Reese case really presents that. Now, there's another case that's coming down the pike. That's the Worth case out of the Eighth Circuit dealing with the Minnesota law. But I think that's going to be coming down the pike much later, and I don't think that's anything that's going to be considered for this term. So I understand why the Supreme Court denied cert and Lara. Now, just to answer one additional question that's popped up about Lara, people are like, well, why didn't they just deny cert in our favor and not GVR? And I think the logic, and I'm not making excuses here, I'm not on the Supreme Court, I'm just telling you what I think the Supreme Court is thinking, is, if you recall, the Rahimi case was decided in June of 2024, and what they did immediately was they GVR'd, meaning they granted cert, vacated the lower court decision, and remanded it back in later. Rahimi, every single case that had been decided before Rahimi that was up on cert. Now, the only difference with the Lara case was that the Lara case was decided by the U.S. Court of Appeals for the Third Circuit before Rahimi, so the Third Circuit did not have the benefit of Rahimi and its logic and reasoning. But it did not come up for cert. In other words, the petition for cert did not arise to the Supreme Court until after the Rahimi decision was decided. So logically, it does make some sense for the Supreme Court to put the Lara case in the same bucket as those cases that were GVRed after Rahimi, because again, the Third Circuit decided Lara before Rahimi, even though the petition for cert came after the Rahimi decision was decided. So again, I don't view this as necessarily a problem from that point of view. Look, I'd like the Supreme Court to resolve, 7 or 8 Second Amendment cases a year in our favor, but I don't get to write the rules and I don't get to wave a magic wand, unfortunately, and make stuff like that happen. So what I want is not important in the grand scheme of things. It's what the Supreme Court does is what really makes all the difference. All right, so to summarize, folks, the Supreme Court made a decision involving the Second Amendment. I don't think it was a terrible decision. I can argue against it. I think they should have the best world might have been they denied cert, but then if they denied cert, it would have looked a little weird if they're going to grant cert in the Reese case in a few months, or in the next 12 months, I should say. So I could understand why they wouldn't want to deny cert in Lara only to grant cert in Reese. I could kind of understand the logic a little bit. Obviously, in a perfect world, we would want them just to have denied cert in Lara, and we'd have the benefit of that victory. But I do understand the Supreme Court's logic in doing what they did, even though it's not perfect from a Second Amendment advocacy point of view. I cannot say it's irrational or crazy from a Supreme Court institutional, what is correct for American law point of view. All right, folks, well, hope you learned something here today at the 4 Boxes Diner. Make sure you follow me on X. More information there at 4 Boxes Diner. And don't forget to like this video and subscribe. We're still trying to grow our subscriber base here at the 4 Boxes Diner. And I look forward to talking to you all again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.